We are 3 days into the winter Supreme Court quackdown. I heard Justice Kagan might break out the pile driver today. If I were counsel for the city of Brandon, I'd watch myself. He looks big, but I think she can take him. Happy Wednesday, everybody. I'm Bryno, and this is the morning report on the federal courts for December 3rd, 2025. You know the drill. Double tap your screen, comment your favorite wrestling move, and watch the first minute right now, even if you're coming back later, so we hit the FYP. Just gonna hit a couple of Supreme Court cases today because I'll be live at 10, and the second one took me 3 days to understand. So by the time I made it understandable for you, I was exhausted. So you sort of get what you get today. Grab yourself a coffee. Let's dig in. All right, first, we actually got a new opinion from the Supreme Court last week. Technically, we got two, but I'm going to save the other one for later this week. This is Pitts v. Mississippi, which is a case about the Sixth Amendment Confrontation Clause right of a criminal to face his accuser when the accuser is a child. So, at the risk of bumming everybody out first thing in the morning, this is a 6-year-old bringing accusations against her father. I'm just going to leave it there. And the prior case law said that even though the Confrontation Clause gives the accused the right to face his or her accuser, a court can put up a barrier between a child witness and a defendant to protect the child from trauma caused by the testimony. Although, technically, only as far as that trauma might prevent the child from testifying properly. We are a cold-hearted bunch, lawyers. So, the law in Mississippi basically says just that. You can put up a screen or something to block the kid's view. But the court in this case, when justifying putting up the screen, said something like, Mississippi law requires a screen for a child. And that was the only reason the court gave on the record, and the Supreme Court said, They don't have a problem with the screen, but this is a constitutional guarantee. You can't just toss it aside and blame it on a statute. You have to do something more to determine that the screen is necessary. Anything. Hold a hearing and explain it on the record. Say, this is a 6-year-old accusing her dad. Something. And so that's the ruling of Pitts v. Mississippi. If you're going to overrule the Confrontation Clause, you have to do some sort of a proceeding to explain why on the record. And by the way, the Supreme Court even said, do not have another trial, don't drag this kid through anything else, but hold a hearing and demonstrate on the record that the screen didn't impact the trial or negatively impact the defendant. That's the least you can do for this case. So I think it makes sense. This is a direct constitutional protection. If you're going to just brush it aside, holding a hearing on the record is a fair minimum requirement, I think anyway. All right, let's get to the Supreme Court's hearings today. Today we are going to hear arguments in Olivier v. City of Brandon, Mississippi. This is a case about Section 1983 of the Civil Rights Act of 1871. So Section 1983 allows us, you and me, to sue for financial compensation if the government, state or federal, violates your constitutional rights. So Section 1983 cases are only about money. Problem is, before the court can say, you owe this dude money because you did something bad, they first have to say you did something bad, right? That's sort of implied. Hold that word in your head, implied, for a second. Because it gets complicated when you have to imply that a state law has violated the U.S. Constitution. That's not something you just want to imply. You say it or you don't. Go big or go home. So in some sticky situations, the federal courts won't hear a 1983 case until those underlying questions have been answered somewhere else. Once it's totally clear that this person's rights were violated, once that question is decided, then we'll decide how much money they get paid in a 1983 case, and whether they get paid, but money, you get the idea. But one situation where this is particularly sticky is in criminal law, because a state court has issued a final decision that our duck here is guilty of a crime. And a 1983 federal court case would issue a final decision that our duck here is owed money because he was unconstitutionally convicted of that crime. Well, how can he be guilty of the crime and the crime be unconstitutional at the same time? Because the 1983 case doesn't undo the state decision. That's not what a 1983 case does. It just talks about money. You're using a hammer to saw wood. Wrong tool. And having two standing court orders that say opposite things is a problem. We don't like that. So how do we deal? Well, according to a case called Heck v. Humphrey, a person who's been convicted of a state crime and believes that the conviction violated their constitutional rights can bring a 1983 claim after they get that conviction overturned. You have to deal with whether the conviction was wrong first, then you come to the federal court and ask for money. But to get your conviction overturned, you're going to have to go all the way through the state court system and then maybe even apply to the U.S. Supreme Court. But this isn't going to go to a federal district court. That's just not how we do it. If you want to come to federal district court, they will hear your 1983 money claim once you have settled the conviction issue, but they won't do both at once. Again, hammer and saw. So, general rule laid out in Heck v. Humphrey. You get convicted of a state crime, you appeal it all the way through your state court and maybe to the U.S. Supreme Court and get that conviction overturned in state court first. Then you come to federal court under 1983 and ask for money. Got it? Okay. But Humphrey also talked about one exception to this general rule, the one time you can bring this question directly to federal district court, and that is if you are in jail. Because if you're being held in violation of the Constitution, that's another animal. And we have a different remedy for that called habeas corpus, which basically means, help, I'm being jailed unlawfully. And Heck v. Humphrey does say that if you have habeas corpus in your state, you have to try that first. But if it doesn't work, you can come straight to the district court with your habeas corpus case. And since by the end of a habeas case, they're going to have to decide whether your conviction was unconstitutional anyway, while they're rooting around in there, they can tell you if you get money for it too. So habeas corpus, because you're in jail, is the one time you're allowed to bring a 1983 case for money directly to the district court, even though your state conviction is still in place. Well, what if you never went to jail? Or are you just blocked from that exception? Because our case today is about Gabriel Olivier, who was arrested but given a suspended sentence and never went to jail. So he can't bring a habeas corpus case because he was never unlawfully jailed. He was never jailed at all. Does this mean he can't bring a 1983 case if Mississippi won't overturn his conviction? That's the question before the court today. And more specifically, does Heck v. Humphrey apply to people who've never been jailed? So, what happened to old Gabe? Well, Gabriel Olivier was what we'll call a sidewalk preacher. He liked to go out in public with a bullhorn and tell people they were going to hell and call them colorful words like whore and Jezebel, fornicator, drunkards, and sissy. Things that go down really well outside of a crowded concert venue in Mississippi. This was causing a lot of problems in the little town of Brandon, particularly at their brand new amphitheater. According to the city of Brandon, Gabe loved to set up outside these big amphitheater events. Police would have to abandon their post to break up fights and try to stop people from walking in the middle of busy streets to avoid Gabe and his buddies screaming at them on the sidewalk. So the city passed an ordinance requiring that protesters, including Mr. Olivier, did their shouting in a designated area about 250 feet away where they wouldn't mess with traffic flow. And they told Mr. Olivier this one day. He left for a little bit, but then he came back. So he was arrested for violating that law, given a 10-day suspended sentence. He did not get any actual jail time. Now he'd like to sue for compensation under 1983 for a violation of his First Amendment rights. And there's a question whether his First Amendment rights were violated. That may be discussed today. States and cities are often allowed to designate areas for protests as long as they don't accidentally discriminate by viewpoint. Time, place, and manner restrictions in public forums are often legal, but I don't know if we'll discuss that. Keep in your head though. But 1983 is a powerful tool for enforcing the Constitution. Should it be withheld just because someone wasn't sent to prison? And that's a question we will definitely be discussing today. There's one really interesting thing you need to listen for, because when Justice Scalia wrote the main opinion in Heck, he looked back at the common law tort of malicious prosecution, which he said was the closest thing to 1983 when the statute was written. So they probably used it as a model, and malicious prosecution required that the underlying conviction be overturned first, before the money. So he said it should be the same with 1983. Now, I don't actually love that, but it may be super important today, because the only judge from that court who's still on the bench is Clarence Thomas, and Thomas wrote a concurrence to Alito's opinion. He said, habeas corpus and 1983 are really similar. They're both about undoing a screw-up by the justice system. One, you let the jailed person go, the other, you compensate the person. But he said they're also designed for very rare use and very narrow scope. They should only be allowed in extreme situations. Again, I'm not sure that's true, but he's got the robe, so let's listen. And he says the courts over the years have screwed up and made these things, habeas in 1983, broader and broader until eventually, boom, they ran into each other. And now we have a case where, and a bunch of cases where both apply, which he says he does not like. But he says, we made this bed, the court, so we're stuck with it, let's fix it. And he really likes that in Heck, Scalia did what he could to narrow these two things, and particularly that he used the common law to do it. He looked back to historical precedent. Now, I don't know if that's going to be important, but keep it in your head in case it comes up. If he starts talking about common law or malicious prosecution, you'll know what he's talking about. One final thing, Mr. Olivier has also brought his 1983 suit because he wants to stop the government of Brandon from enforcing this law against him in the future. So he says that part of his lawsuit isn't about his past conviction. He doesn't need to overturn the past one if all he's trying to do is prevent a future conviction, and he says he should at least be allowed to move forward with that part. Counter-argument is that federal court would still need to state that this law is unconstitutional. His arrest was unconstitutional in order to process that claim. So the end result is the same, and they need the hammer to do its job before they start sawing. All right, that is your Wednesday morning report on today's Supreme Court Quackdown. Quick thanks to Austin for the Venmo support. I really appreciate it. Please consider subscribing below. Check out the link in my profile to help me stay sustainable. I will see you at 10 for a new round of Supreme Court Madness. Thanks a lot, everybody, and have a great Wednesday.